My name is Richard Glinsky. I am an estate planning attorney and the founder of Insightful Estate Planning. The purpose of this presentation is to equip you with a high-level overview of the ins and outs of estate planning, as well as to give you a good foundation for your upcoming estate planning consultation. I want to share a little bit about myself. I was born in Belarus, and from a very young age, I learned that my parents will do anything to protect me and my two brothers. When I was just 6 years old, they chose to move our family to an entirely new country with the hope to give us a better life than they grew up with. As I've grown up, I've come to learn that people from all walks of life have somebody they love, care for, and will go to great lengths to protect. And that's why I love estate planning so much. It's because it gives me the opportunity to help families create plans that will protect their loved ones for generations. Now, when I started my career as an estate planning attorney, I quickly realized that there was something really wrong with the estate planning industry. There was a ton of misinformation out there, and attorneys would often force their clients into plans that the clients really did not need or even want. After a certain point, I said, you know what? I can do better for our community. And so, Insightful Estate Planning was born. Your goals are the single most important piece of your entire estate plan. Everything else, including the documents, comes second. Now, many people want to focus immediately on the tools, on the documents involved when thinking about their estate plan. And it is true, there are lots of documents involved. There are wills and trusts and financial and medical power of attorneys and healthcare directives, and the list goes on. However, if you want an estate plan that actually works, the documents must come second. I encourage you to think about the things that you would like to happen should you ever become incapacitated or pass away. Perhaps just as importantly, what do you hope does not happen? And so what are your goals? Is it to prevent conflict and disputes between family members? Is it to ensure a smooth transition after your passing so that money and time can be as efficient as possible? Is it to avoid probate? Perhaps you have a family member that went through probate process and you want to do better for your family. Is it to protect your children's inheritance? Is it to save money and avoid estate taxes? Because Washington State has its own estate tax. And with good proactive planning, we can avoid a lot of it. Is it to plan for incapacity, which leads us to our next point. When most people think of estate planning, they think, what happens when I die? And this is certainly part of a good estate plan. However, your estate plan starts while you are still alive. And so if you are alive but you become incapacitated, who will make financial and medical decisions for you? Who will advocate for you? Who will ensure that you, and perhaps just as importantly, your children, are taken care of? This could be a physical issue, it could be a mental issue, it could be permanent, or it could be temporary. But the scenario is you need help managing your money and you cannot make your own decisions. A friend of mine shared a story with me. A woman called his office and shared that her husband was shoveling snow on the driveway, slipped, fell, injured his head, and wound up in the hospital. She was not able to pay any of her bills because she was not able to access her own money. As it turns out, all of the accounts were in the husband's name only. And so now she was reaching out to an attorney to get help getting access to her own money. There were two options. The first option was very straightforward. The husband would sign a financial power of attorney, giving wife the ability to access her own money. That didn't work out. And that's because the husband did not have the required mental capacity to sign a legal document that would give the wife access to money. And so the only other alternative this particular person had was to go through a formal court proceeding called guardianship. Now, guardianship is a proceeding that often takes many months and costs, even in the very straightforward case, upwards of $10,000 to complete. Now, stories like this can be completely avoided by good proactive planning. Your estate plan should give very clear instructions for who should be in control of your financial and medical decisions if you are not able to make these decisions for yourself. And so estate planning starts while you're still alive. So the next question becomes, well, what happens after I pass away? And this is what most people think of when they think about their estate plan, and this is absolutely a part of a good estate plan. And so what really happens now depends on a few things first. Was there even an estate plan in place? Because if somebody passes away and there are no instructions, so there's no plan, we're just left following Washington state rules. And that may or may not align with your goals. And so the next question is, what instructions are left? Do we have a will or do we have a trust? Because depending on the tool used, the next steps are going to be pretty different. And so let's pivot a little bit and focus on the tools. There are many tools that make up an estate plan, and each of these tools serves its own specific purpose. People sometimes ask, Richard, that's all good, which of these documents is the most important? And that's an impossible thing to answer because neither of these are better than the other. They simply do different things. For example, if you wind up in the hospital and your doctor is asking for medical power of attorney because the person that you've chosen should be advocating for you, your will is not going to do you much good. What you really need at that point in time is a medical power of attorney. And so the best tool for you is the tool that you have whenever you happen to need it. This is why at Insightful Estate Planning, we have a very holistic approach to your planning. Each of our estate planning packages includes the necessary tools to cover your medical and financial decisions during your life, as well as these decisions after your passing. And so, again, the question becomes, what are your goals? Many of the families that we work with prioritize a smooth transition after their passing or incapacity as their most important goal. And I have good news for you. This goal is perfectly achievable. However, it requires proactive planning. That's how we get a smooth transition, by planning ahead. And so let's pivot ever so slightly and talk about some of the tools that come into play after someone passes away. There are two basic tools, a will and a trust, and we'll talk about both of them. And the biggest thing people often ask me is, Richard, which is better, a will or a trust? And one is not better than the other. They simply do different things. And a last will is a very important estate planning tool. Now, I often hear many lawyers try to scare their clients into creating a trust, saying that a will is an inferior solution and it's just not good enough. Let me be here to tell you that is not true. Wills are fantastic tools and solutions for many families. A will is a document that accomplishes three basic things. Number one, it appoints the executor over your estate. The executor is the person who's going to be in charge of all of your assets, of all of your stuff after you're gone. So you get to choose that person in your will. Number two, it appoints who will get what. And so it ensures that the right people get the right stuff. So your executor, the person you've chosen, is going to be in charge and control of all of your stuff and all of your money, and they're going to ensure that your instructions are followed and the right people get the right things. Now, the third thing that a will does really only applies to people with minor children. It establishes guardianship over minors. If you don't have minors, then your will is not going to cover that. It's just going to do the first two things. Now, we can't talk about the will without also talking about probate. One of the most common misconceptions I see is people think if they have a will, that means they've done their homework and their estate is not going to have to go through probate. And that's not true. The key to probate is not whether or not you've done your homework, it's how are your assets titled. If somebody has a will, that means they own their things. If they own their things, that means their stuff will likely have to go through probate. And so very, very important to keep in mind that if your goal is to avoid probate entirely, the will may not be the best solution for your family. So what is probate? Well, probate is a necessary court process for many families because most people pass away with assets titled in their own personal name. And so when probate comes in, it gives the executor that you've chosen authority over your estate. And so you have a will where you choose your executor and you choose who you want to get what. However, the will on its own does not have authority. It has to come under the jurisdiction of probate court, where the probate court puts their seal of approval on it, authenticates it, and said, yep, this is an original will. Executor, you can now act on it and you can have authority under this document. So we need probate to give the will authority. Then the executor is under the jurisdiction of the probate court, which brings along some potential downsides and potential reasons why people may want to avoid probate. The first one is private family matters become public information because, as we all know, probate is a fully public court process. So the names, contact information of all the individuals involved is fully accessible to anyone who wants it. Obviously, the court is involved because this is a court process, and private family matters are under the jurisdiction of the court. Many people say, look, I would rather keep privacy in the family, so let's avoid probate because it's public. Probate costs can add up, particularly if there are rental properties owned in multiple states. We call these ancillary probates. So it's not just going to be a Washington probate. It may be an Idaho, Arizona, California probate as well for those particular pieces of property. And so a very common goal for many the families becomes to avoid probate. Now, in some states, probate truly is something that you want to avoid, whereas in other states, you don't even really need to hire an attorney to go through the probate process. Now, Washington falls somewhere in the middle. It's not the worst by far, but it's not the best either, right? So somewhere in the middle. And so everyone wants to know about a trust, so let's talk about it. There are literally hundreds of different types of trusts. There are ILITs and GRATs and CRATs. They're revocable, irrevocable. We're not talking about all of those. Well, we're talking about one of those. We are only talking about the revocable living trust for purposes of today's discussion. And so what is a revocable living trust? Well, first and foremost, it's a private family document. And so that's the first big distinction between the revocable living trust and a will. The will needs the probate court to give it authority, whereas a revocable living trust has authority all on its own because it's a private family document that has legal jurisdiction and authority over all of your stuff by virtue of it being signed by you. The trust works kind of like a bucket. So you see a bucket here on the screen. It's there very intentionally because that's what a trust is. It's a holding container that's intended to hold your assets. And so if you have a cash account, if you have investment accounts, if you have life insurance policies, if you have real property, rental properties, businesses, you name it, all of these assets are intended to be held by your trust. And so what's going to happen is we're going to retitle your assets so that the trust becomes the owner. Now, just because it's in the trust doesn't mean you don't have any authority over it, because you, as the grantor, the person who's creating this document and is control of this document, your hands are holding the handle of the bucket, and so you're in full control. As far as you are concerned, nothing in your life changes in any way, shape, or form. It goes as far as to mean you file your tax returns every year the way that you normally do. So nothing in your life changes. This is an estate planning tool. And so, second point, you have full and absolute control. This tool, the revocable trust, can avoid probate. And we avoid probate because if you pass away and your assets are held by your trust, technically you don't own anything when you die. And so when you pass away, there's no need for probate because probate is for people who pass away with assets in their own name. And so now, through this mechanism, the trust can avoid probate. And so if your goal is to avoid probate, the trust may be the better tool for your family. The trust also gives immense asset protection for children. It's built and drafted around the idea of giving your beneficiaries asset protection from creditors, from people who want to sue them and take their inheritance, from bad marriages and walking away spouses. That money would be protected and would not be accessible by any walking away spouse. And so it's one of the strongest shields known in law, where we can set up a structure to where your children's inheritance is protected for their benefit. There's also the opportunity in a revocable trust for estate tax savings. Now, this particularly only applies to married couples. In Washington State, we have a $2.2 million estate tax exemption. Anything over that gets an estate tax. We can double that through a very carefully drafted trust so that we can protect $4.4 million for a married couple before an estate tax in Washington becomes a problem. Now, people often ask, Richard, trust sounds like something too good to be true. What's the catch? Is there a catch? Yes, there is. It's that a trust, in order for it to work the way it was designed, it has to be funded. And so in the beginning here where I chatted about we have to retitle assets so that the trust becomes the owner, that's how we fill the bucket up. That's the catch. There's a little bit of work involved in making sure that all of the assets are properly integrated with the trust. And so what have we learned so far? Well, we've learned that estate planning is more about your family and your loved ones than it is perhaps even about you. We've learned that your goals are the most important piece of your entire estate plan. The paperwork comes second. And I implore you to be thoughtful and careful with your estate planning because a simple mistake can be costly and devastating for your family. And when I mean careful, I don't mean be careful. I mean put a lot of thought and care and intentionality behind your plan. And so what should you look for as you decide who to work with for your estate planning? Well, I encourage you to look for an estate planning law firm that focuses on estate planning. Now, here at Insightful, estate planning is all we do. Another one to look out for is if someone charges hourly for planning, it's probably a sign that they don't do the work a whole lot. In this day and age, estate planning should really only be charged on a flat fee basis. Now, an estate plan that works cannot be one and done. Our lives change over time, and so our estate plans should be updated to reflect these changes. I encourage you to find a firm that has an opportunity for an ongoing relationship program, because an estate plan that works must be updated and maintained through the years. Now, fortunately for you, Insightful Estate Planning does have an opportunity for an ongoing relationship program. And unlike many other firms, we do not charge over $1,000 a year annually for it. We offer our program for free. And so 4 basic benefits that are included at no additional cost to you just by virtue of you creating your estate plan with our firm. Number 1 is an annual check-in reminder to review your estate plan every year. We know that life goes on and things get backlogged, and it becomes easy to forget about even the most basic things. So we reach out and we remind you to take a few minutes and review your estate plan. The second benefit is we will offer 1 free meeting with your family in case you become incapacitated or pass away. And that becomes a really important meeting so your family understands what the estate plan said, how things are structured, and what the necessary next steps are, and we're not going to charge for that. We also offer exclusive annual educational seminars focused on very practical estate planning issues that could be really valuable to you and your loved ones. And by the way, we actually encourage our clients to communicate with us, so we do not charge for periodic check-in emails or phone calls. Everyone knows that attorney that nickels and dimes for every communication and every email and every phone call. We don't want to be that law firm. And so if our clients want to reach out to us with certain questions and just check in every once in a while, we're not going to charge for that. And so all of these benefits are included at no additional cost to you. Our goal is to create an estate plan that leaves no stone unturned and gives you the peace of mind knowing that your loved ones and your intentions are protected. Now, how to accomplish this? Well, it's through our simple but proven process. Your next step is to have a 15-minute introductory call to ensure that we're a good fit for one another. The second step will be to conduct a design meeting to design your estate plan. The third step will be to give you the opportunity to review your estate plan and share any changes that you would like made. And finally, step 4 is that's where we have our signing ceremony, where you sign your estate plan, giving you the peace of mind knowing that your loved ones and your intentions are protected. Thank you for taking the time to watch this presentation. We look forward to your upcoming introductory call. I hope that you have a great rest of your day.